Law matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. This program has been created to educate, inform, and help you with law matters because the law matters. Understand the law better, you're in a better position to decide how to protect yourself, your family, and your business. As we always say, we provide information and resources that help you decide whether or not you need or want to contact a lawyer. In some cases, perhaps you'll be prepared enough to handle some issues yourself. If you do decide that you need outside counsel, we're hoping that that professional will be better prepared and you will receive a better result, save time and save money, just have it work out better. The Bazar and Associates law firm in East Providence continue to donate their time and their efforts and their energies and expertise on the issues that we tackle, and we want to welcome and thank
you, Debbie.
Counselor Bazar. So today, kids, what's the matter with kids today? Juvenile system, juvenile justice, the juvenile court system. Roughly speaking, juvenile justice is supposed to incorporate courts, social services, enforcement. But to try to pin that down or get a more precise definition, it's kind of complicated and it varies across the country. In fact, there are some states that still do have what's called a juvenile court, but not always. Now it's more likely been folded into the family court or the unfamily court, as it may be. If a 14-year-old happens to jump behind the wheel of a car, doesn't have a driver's license, causes an accident or a death, convicted, incarcerated for years, how should this and lesser crimes actually be handled if it's committed by a child or a teen? It needs to be handled responsibly. Does that happen? There are so many common offenses that hit kids today. It's maybe theft, it's simple assault, maybe it's drug abuse, some sort of curfew violation. Apparently, according to the Juvenile Justice and Delinquency Prevention Office, a federal office, they say only about 3% of the crimes that are committed are malicious and violent and rape and murder. But nevertheless, today we're going to talk about what's in place in terms of the court system, how do you fix and rehab versus punish a kid. So, how do we handle this? First off, what is juvenile court system as it is today and as you know it?
Okay, so primarily I think what you're talking about is a court system that's in place for children who commit crimes. And in Rhode Island, for example, there's the family court, which has a couple of different units or areas of practice. One area of practice, as we always have talked about in the past, is the domestic side, as they say, which is divorce and child support and custody and placement and all of the issues surrounding the family in that sense. Then there's the DCYF side, which is when children are at home and suffering from abuse or neglect or something of that nature, the DCYF steps in and brings, in some instances, the matter to court for a judge to decide whether a child should be placed elsewhere, taken from the family, parental rights terminated, and all of the things that go along with that. And then there's the juvenile side, which would be the criminal type of activities done by or acted out by children and are adjudicated in that side of family court. So there's a lot that goes into the juvenile side of the family court in Rhode Island specifically.
So for one question, as I was reading and preparing for this, David, I assumed that juvenile meant minor, under 18. Apparently not just and only across the country. What's the status in Rhode Island or in our southeastern Mass area?
So the jurisdiction actually is a very interesting thing. So you commit an action that amounts to a crime if you were an adult, felony or misdemeanor, depending on what it is and how severe it is. So if you are under 18 when you commit the crime, it is possible, and we're going to talk about when it's not, that you could be prosecuted and handled, so to speak, in the family court in the juvenile system. The family court in the juvenile system has the right to keep track of your case until you're 21, actually, so beyond 18. But if the crime is committed before you're 18, then you potentially can stay in the family court system. We also had some jurisdictional issues that came up when Rhode Island changed that, and they made it 17. and you could be treated as an adult. And then they took that away, and we had cases which we called the gap kids, for kids who committed crimes when they were 17 at a time when that could have been just brought directly to Superior Court or District Court as an adult, but then was changed back. So do we treat them as juveniles or do we treat them as adults? Luckily, all of that mess worked its way out of the court system. So now we're really just dealing with what court has jurisdiction and when it should invoke its jurisdiction. And we can talk about when the family court might waive a juvenile out of its jurisdiction.
Do you want to do that right now? Because I have the other question about even younger than this 14, 15.
Right.
So finish with that, David.
Okay, if you want. I'll remember, I'm not that old yet. So here's the deal. If you remember back to the Craig Price case.
Yes, that's a very good example.
Right.
But maybe you better highlight it because perhaps not a lot audience knows it.
It's gone back a long way, so some people may not have been around or remember that case. But Craig Price was a young person, very young actually at the time, who committed several murders. And my recollection is he may have been 13 at the time of one or thereabouts, and maybe 14 or
13,
15
14 something. Mm-hmm.
in the next. And at that time, you couldn't be waived out of family court. So they had to treat him as a juvenile. And what happened was, if you remember what happened with him, they kept him at the training school for as long as they could, and then he committed some acts in there which allowed them to hold him further at the ACI, and then he committed some more acts there, and they, I think to this day, are still holding him. But they couldn't, at that time, waive him directly to Superior Court to be treated as an adult because of the way the law was written. So the law changed because of that case. And so what happened is a family court judge could waive somebody. At that time, you could get waived out, I think, if you were 16 when you committed the crime or older. So they changed it to you can get waived out. Really doesn't really matter how old you are, although that impacts on whether you'll get waived out. And what waived out means is that you won't be part of the juvenile system. You'll go directly to the adult system based on how serious or heinous the crime is that you committed and the circumstances surrounding that. So the family court judge has discretion in the first instance in some of these cases to decide whether or not to keep you in juvenile court or waive you into Superior Court.
I do want to talk about that whole process, but for the moment you mentioned the judge who was discussing the case or talking about Craig Price or whatever else. Is it true without exception that it's always going to be a judge and not a jury when it comes to a juvenile case?
Okay, so the answer is yes, and that really brings you to the next aspect of what is the difference between juvenile court and adult court. And really the difference is a juvenile court is really not set up to punish someone for committing a crime. It's to rehabilitate and to help somebody with problems or issues that they have as a child that we're hoping we can counsel them through or get resolved for them while they are still children. Whereas, of course, Superior Court, District Court, adult crimes are set up for punishment, to punish someone, to deter other people from doing the same kind of act and to make sure that they don't do it again or learn a lesson or whatever. So there's a bit of revenge aspect to punishment in the adult system. There's none of that theoretically. There's not supposed to be in the juvenile system. It's all about rehabilitation. And when I was once interviewing in front of the Judicial Nominating Commission for a position in family court, someone asked me a question. And the question was really, do I see people as all, no matter who they are, having some good in them, or are there just some bad people? And of course, that led me right to the discussion of what juvenile court's supposed to be for. Juvenile court is supposed to be that we know that everybody has some good in them, and how can we get to that point and resolve the issues that stop that from coming out in a person. And then, of course, you look at a person like Craig Price and you say, I don't know if there's anything but evil in that person, and that's the kind of person that should just get waived out of family court to Superior Court. So the first instance is that what is the two different things? Juvenile court set up to rehabilitate someone, really not to punish. Adult court, it's got a punishment aspect to it.
In my research, earlier court systems, there really was just a juvenile court system, and it was with the understanding that all kids are good, but somehow something happened along the way. Let's hope we can intercede before bad behavior becomes really a life of crime. And the setup was such that there was, of course, more of a family structure, and it assumed that when the child got into trouble, whatever trouble was defined as, that the child would not be immediately removed. It was, let's just see what we can do to help this offender rather than just look at what that offense equates to in terms of just punishment. So there was some individualization of or tailoring of what was going to be done with the child. Let's see if we can find out what the cause of the problem is, and let's see if we can put something in place, as I referred to earlier, community service, a counseling, or something, or training of some sort that could be helpful to the child, keep him in the home, and hopefully set him aright before something else happens. Do you feel that that's still a possibility? I know you say you want to, there's rehab or the interest in rehabbing. Does that really happen?
Well, exactly.
As it should?
Yeah, it is what it should be, and it does happen. And in fact, the family court in Rhode Island has also set up now what I would call an intake unit. And that is a unit that looks at cases that may not arise to the worst type of crime or situation in the world, where they want to even keep that juvenile out of the court system.
Entirely.
Entirely. So you go in, I've had many clients I've gone in with, and you explain the situation to what happened to the intake supervisor or the person who's reviewing your case, and they look at all the circumstances, as you said. Why would you have done this? What did you do? Why did you do it? What's going on at home? What help do you need? Do you need some help with drug screenings and counseling in that level? Do you need just to do some community service because you made a bad decision? Not a horrendous decision, but a bad decision. And so they do try to help somebody immediately with counseling or with community service if it was just a bad decision, or something where you learn from what you did, learn from your mistake, and don't have to go through the court system, don't have to be branded with something. Although in juvenile situation, usually no one else can find that after you turn 18. It's supposed to be.
It's supposed to be sealed, as I understand it, and kept confidential, but not automatically expunged, from what I've read.
There's a record, if you go through family court, that's always going to be there, and no one's supposed to know about it, but there are certain agencies and certain ways of finding out, so if you can keep somebody out of the court system itself, that's a good thing. Like I believe if you apply to be in the military, for example, they can find, you have to be honest, and they could find out anyway.
Yes.
And I think some enforcement, police agencies, FBI, whatever, might be able to find out. But theoretically, your juvenile record is supposed to be sealed and no one is supposed to find it, but it can be.
Sounds like it's worthwhile to check up on that, because even in other segments that we've found out, we've discussed that someone was applying for a job and then couldn't even serve in a PTA because there had been some offense in his prior life.
Usually as an adult, and usually something that should have been taken off the record they thought was expunged but didn't come off. So the idea is, back to that intake unit, let's find something that helps this child to learn from this mistake and keep them out of the court system.
And while we're speaking of youth here today, I had read, and I hope you can clarify, that there are actually some occasions where, say there's a child under the age of 7, where they are considered to not know the difference between right and wrong, and therefore are incapable of having a guilty mind, quote unquote. Is that true? What's the situation with that, as you know of it?
There is some aspect in the law as to how old a child is before the child has the ability to distinguish between right and wrong, so that they would know that what they did is a crime. And there's a more important thing to look at, usually at that young age, is what's going on and why did that happen, and what's the family structure and what's going on in the family unit, and try to help the whole family so that we can figure out what's going on. But there is an aspect of the law that covers that.
So at this point, David, help us understand what happens from, for example, the time that a young person is arrested by the police, or at least tapped by the police. Apparently, in some cases, the judge, I mean, not the judge, the police have some options about how they want to handle it before it even gets to a place where someone's calling you because it's potentially a case.
Right.
What are some of those options, David?
So almost every police department has somebody who's in charge of their juvenile prosecution. So somebody does something. Let's give a hypothetical. Say the police officer arrests some kids for underage drinking. All right. So now it goes to the prosecution part of the police department. Do they want to bring those charges directly to the family court and try to prosecute it through the court system? Or do they want to, in some cities and towns, have a juvenile board that they can bring it to, and the board will give community service or counseling or something like that? Vandalism, perhaps, they might have them do some community service of fixing things and get counseling if that's called for. Or do they want to send it to the family court and have the intake unit take a look at it, especially if the city or town doesn't have its own juvenile board? So the prosecutor actually has some discretion, just like in an adult case, in the beginning to determine whether or not something should be prosecuted. And we've actually, through an election season, have heard about prosecutorial discretion and whether something amounts to a crime that can be prosecuted or not.
Or not. In some cases, if a child does something that is just misbehaving but no real consequence, just not nice, the police officer might be able to take that child to his home, in the custody of his parents, maybe make the parent pay for some damage. You smashed a pump. You smash your pumpkin in a mailbox, pay for the mailbox, and we don't really want to see anything terrible happen. Is that considered a reasonable path and something that you might typically expect among juveniles?
Sure, I mean, that's possible. It might be restitution to the neighbor's neighbor's mailbox and some punishment at home if the police officer is reasonably confident that the family is going to be able to handle this situation and it's going to be handled appropriately and that there's no more intervention that's necessary. Like I said, that might be step one. It might be step two if there's a juvenile board to bring the child to the juvenile board, which is not a court system. You don't have to go. You can waive out. You can say, no, bring me somewhere else. I'm not doing that. But it's a much more informal way of having some third party help weigh in and help with resolving the problem, or like I said, the intake center at the family court.
So for our purposes here, we try to provide resources and give people guidance about how they should handle things. In some of these instances that we've spoken about, the child smashes a pumpkin and hurts someone's mailbox versus underage drinking. At what point is it such an infraction that the parents could step in and handle it themselves? At what point should they not, and should they instead call a lawyer to make sure that it doesn't go any further along and into the court system, so to speak?
Well, actually, it's very interesting. And it's an interesting question because of the way you asked it and from what perspective you're asking it from. The way you originally started asking the question, and I've handled cases like this before, is where a parent has trouble controlling a child and is not able to get the child to do the things that the child should be doing, and they want some help with that. And so I have had cases where what the parent can do is to file a petition through the police department against their child, a wayward or delinquent petition. And what they're saying is that this child is not following the reasonable rules that are set at home. Yet you usually are very reluctant to do that, but I've had cases and situations where the child refuses to do drug and alcohol counseling, the child refuses to go to a mental health counselor, whatever it is, won't listen to the rules at home, stays out, doesn't come home, does all of these things. So what we did in one of those instances more recently is we went to the police prosecutor and we presented the problem to him. And he could have said, I'll go talk to the child for you if we thought that would have happened, but we thought this child was beyond that. So this town did not have a juvenile board. That wouldn't have helped. So we asked him to get a petition ready to file, contact the family court intake service unit, and get that level of involvement in this case. Otherwise, it would have had to go in front of a judge and creates all those other problems that I talked about.
Yes.
We didn't want to quite get to that level, but if we couldn't get the child to get this resolved at that intake level, we would have had to go that route. So sometimes it's the parent who's saying, I need help here, this is not working, and this child's breaking the rules and I need some help with it. The other side of the coin is when the police come to you as the parent and say, your child has committed this crime and we're going to charge him and serve you as the parent of the child and bring you to court. And that's where you hire an attorney to, it's just like defending someone in a adult case in Superior District Court, except, of course, as I say, in the family court, what we're trying to do is rehabilitate these children and make sure that they either learn from a lesson that they shouldn't have done or get the help that they need. And so, as an attorney, we might try to help direct that case to the intake unit and keep it there. I've gone, like I said, on many of those cases to make sure we keep the case there, that's where this case belongs, and make sure my client and their children, or child in this case, follow the rules. So yes, whenever you have a concern about a child, contact an attorney if you can't get it resolved, or if the police are telling you there's a concern, I'd hire an attorney.
Okay, what about something like delinquency, truancy?
Okay, so wayward
Child.
wayward, delinquent, truancy, 3 different types of charges. One
Okay.
amounts to what would be a misdemeanor as an adult, the other which would be a felony as an adult, and truancy, not going to school. Again, in Rhode Island, they've created these truancy courts, which are family court magistrates who go to the school and will have hearings. Before they did that, the child would be brought to family court on a truancy petition. And the judge would try to go through this situation. What's going on at home? Why isn't this child going to school? What can we do to make sure the child goes to school? And it can get to the serious level of you go to school, you're going to the training school, and you know all about Sakanasset and what goes on there.
And I suppose while we're talking about what parents could, should do and when they should, what about in the rare occasion, and there are rare occasions, when children decide to be emancipated? Then they get into a little trouble and they're underage. What happens then? They better call you because they really don't know what's going on and what courts are. Is that true?
Well, you've raised another very interesting issue. What do we mean by emancipated? Did they go to court actually as a juvenile and become emancipated from their parents?
Yes, let's assume that for the moment.
Okay.
It doesn't happen often, but
Right.
just in that rare occasion,
Yeah,
what do you do?
so it's my understanding of that petition that you are saying to the court that I do not need the support of my parents. I do not need to be told what to do by my parents. I'm responsible enough to make my own decisions, and therefore I don't want to live under their rules, and I want to be emancipated from them. By doing that, you're saying basically, I want you to declare me an adult.
Yes.
And if the court declares you an adult, then whatever you do is as an adult.
So suddenly that smashed pumpkin that broke the mailbox isn't quite viewed the same way?
Right, it could be disorderly conduct, it could be vandalism, that might be a misdemeanor that you're going to district court for instead of being a 17-year-old going to the intake center.
The things that we bring up in this program. Children, juveniles have constitutional rights too. And I guess among them, do they have the right to have their case heard by a jury? We talked earlier about
Right.
it being a judge.
Yeah, so
What happens?
There have been cases challenging this around the country before, and in Rhode Island there's no jury in the juvenile court system, in the family court system. There's a jury in the family court system for adults who are being tried for certain crimes that family court has concurrent jurisdiction with Superior Court over. But it has been based on the whole notion that we're not trying to punish a child, we're trying to rehabilitate a child, therefore there is no right to a jury.
Okay. What about the idea that you have a right to confront your accuser? That child smashed the pumpkin and put it in my mailbox. I as the child, I want to prosecute. What happens then?
Yeah, well, you do have a right to a trial. You have a right to confront and cross-examine the witnesses that are presented against you. You have a right to present your own testimony on your own behalf or testify on your own behalf. I would argue that you have a right to assert your Fifth Amendment right against self-incrimination, so they can't force you to testify. There are certain rights that I think you still have that you do not shed at the courtroom door, so to speak, because you're a juvenile. The only one that I have not been able to see regularly convinced in most states is that right to the jury.
Okay, good to know. For the cases where a child is going to be punished, is punishment considered training school as opposed to being put in a prison, which they're not supposed to?
Well, as a juvenile, if you're going to be confined, you're confined to DCYF. You know, you're transferred to them, who would then place you at the training school. And that's not a place where you really want to be.
And when you think about the cost of it, something like 3 times the cost of what Brown University would be, is the training school at all set up to help surround the child, uplift the child, give them community skills and educational skills and vocational skills, or are they just and only prepared to put them in the confines of the box?
No, theoretically, you're correct. It's supposed to provide services and training and counseling and all of those things.
And how well is that working?
Yeah, that's a good question.
So he says. But it's certainly something that is very difficult because even the educational school systems have enough trouble putting
Right.
together vocational programs and educational and support, and DCYF coming in helping the kids. It's
Right.
still a problem.
The problem really isn't as much as what programs are available. The problem is we're putting some kids in who may not be that bad, with some kids who are really bad. And is it really a training school to be prepared for a life at the ACI afterwards, or is it a training school to try to make it so that you would never commit a crime again? There's too much opportunity for the wrong kind of training to go on, which isn't the state's issue in the sense that it's
Yes.
not what the state program is, it's what happens while you're there.
And considering there's always reforms that are proposed, how do you feel about the reforms that have been made in the juvenile court system to date?
Yeah, well, it's not an easy issue.
Right.
And it's something that the state should continuously look at, and how can we provide services better? You know, it's expensive, and there's limited funds in many instances, but how can we spend the money more wisely to provide better services, to make sure that people who need the services are getting the services, and that they're services that might actually work?
Sounds right. Parting shots. Well, I was going to say, in terms of what they're doing with the criminal justice system among juvies, are they having any reports of success so that there is less recidivism because of the interventions that are going on right now? How do you feel about that?
Well, I'm sure that there are, and I've not seen any studies, and I don't know, and I know that there are people who study this all the time, and we have the child advocate,
Yes.
who will definitely be someone who looks into that, and maybe at some point in time we ought to get her on and have her help address some of those issues.
I understand that there's research going on across the board in terms of the criminal side of it, the detention side of it. We'll have to follow up on that.
And the real big issue is, what about the rehabilitation side of it?
We'll continue. We hope that this has been helpful to you, as we hope that you or your children do not have these issues, but if you do, we hope this has provided some helpful insights. So stay tuned to The Law Matters, because the law matters to you.